I get that this is a conference not just about what do we think about legal tech, but something to form and formulate an agenda, particularly around empirical research. And I sort of welcome that opportunity, because I have, without the exposure to the same supply of conferences and meetings as Dan and some of the others of you, I do know and come away with the same sense of, I don't know if exasperation is the right word, but unfulfillment, that we don't have an action agenda from that. And this is, of course, one element of that agenda. So what I thought I'd do is talk a little bit about perspectives from Northwestern to try to introduce some uncharacteristic humility on my part, because this is really about perspectives from one law school. Some of what we do overlaps with the work that one finds in a number of other law schools. Some, of course, of these initiatives have been swiped from others' playbooks, right, happily, and some the opposite. But it's just sort of a window into what one law school, prominent law school over a particular period of time, has been aspiring to do in this space, and welcome your input in that regard. So where I come at this principally as a full-time proud academic with a quarter-century-ish career in that, is not from the technology side, but really from, in some sense, outer space in a different sense, which is legal theory and the history of legal education, seeing that the development and the focus on technology is, broadly speaking, a new development, not a brand new development, but a development that is conspicuous and important over the last several years, but takes place against the backdrop of a kind of education that is more than a century old, is profoundly and famously conservative, is importantly path dependent, is backward looking, is the amalgam and the admixture of decisions and choices made by a wide variety of law schools over a long period of time, but in many important respects all begins at Harvard, right? More than 100 years ago, with the development of the case method and Christopher Columbus Langdell and what began as an exhortation, less than a decree, but it eventually swept the world. So much so that many of the elements of legal education to this day are the products of choices made more than 100 years ago. As my torts professor at Harvard used to put it when I went to law school, which was a long time ago, but not in the 1870s, he said what's really striking about legal education is if you sort of woke up a lawyer, as it were, from the 1890s and described to that lawyer what the curriculum looks like as I was there in the mid-'80s, but you could say up to the present, doesn't look all that different, because still the way in which we think about legal education, certainly in the United States, has an extraordinary stickiness. There have been changes, and the attack on the Citadel, you might add a longer bullet point list. Here are some highlights. The McCrate report comes out in the early 1990s and throws down the gauntlet, right? Bob McCrate, president of the ABA, got to have change, much more experiential education. Legal education can no longer be decoupled and disconnected from practice. So get to work, law schools, in radically changing your curriculum to modernize it and bring it up to date with the realities of professional education. And along with that, albeit many years later, came the Carnegie Commission report, which really made this point. And added to the McCrate insight in essentially this way. Other fields are doing it. What makes lawyers think they're so special when our colleagues in medical school, not to mention other parts of the academy, but certainly in other professions, understand the intersection between theoretical foundational knowledge, right, legal reasoning, how to think like a lawyer, but also practical training in the structure of legal education. And again, the exhortation was to get to work. In recent years, there have been a series of task forces from the ABA. We are in the third iteration, in some sense the most extravagant iteration, as a result of President Hillary Bass's decision to create about a year ago a permanent, not a task force, but a permanent, to the extent you could say anything in the ABA is permanent, committee on, I knew they'd get a laugh out of Chase at least, committee on legal education. Along with it, less well known, but very important, have been a series of state bar task forces in places like California, New York, Florida, states you might have heard of, Illinois, that have purported to say we've got to do something to regulate. So spending a lot of time on this slide to really underscore the point, there's a lot of turbulence in legal education. And what I think about when we develop initiatives in the area of technology, in the area of business, in the area of clinical experiential learning is why we think we're so special in supposing, and the we are the cluster of law schools. In a tweet yesterday, Richard Susskind put the number at approximately 20 in the US. And I was ready to quibble and quarrel with his description, but actually he had that probably pretty right. I mean, I don't know how Dan feels about that in the much more elaborate innovation index, but I could name probably about 20 without breaking a sweat, and then I would slow down. American law schools that can be said in 2018 are making substantial progress with respect to innovation. That's a tenth of all law schools, but it's a running start. Again, I talked a little bit about that. The sort of the three stages, the citadel, as it were, of we are doing in law school fundamentally this. We're training our students to think like a lawyer. We do it in the first year with a highly prescribed curriculum, not particularly experiential, largely driven by the case method, extreme reliance, many would say, I among them, over-reliance on private law subjects, in order to inculcate in them not only substantive knowledge, but the values that they are to take with them to the second and then to the third year, that at the other end is to give them the experience. I'm not going to try to do my Kingsfield impression, you'll be happy to know, to think like a lawyer. We also more recently are expected, and in many instances schools obligate themselves, using this or another phrase, to develop practice readiness. As Jim Lupo and I and so many others have talked about in our efforts and energies to create the center that he's going to talk about, and others, we at least at Northwestern, and I think at a number of other law schools, wince at the phrase practice readiness and prefer some version, some variation on the theme of developing professional proficiencies. Technology, to finally get to the point, right, and the point of this conference, technological change introduces itself. It's choose your phrase, du jour. It's destabilizing, it's disruptive, it's cataclysmic, it's impactful, and it has made a difference to a greater or lesser degree on, in no particular order, the economy, social structures, on legal education, and on the delivery of legal services. So some examples of how this is the case, and I know I'm in a crowd preaching to the choirs, but some, not complete examples of which is the case, is the rush of big data, and I'd say at the topical level, the importance of big data in our business model. That has been proved to be, in my experience as a law teacher, quite challenging for us in law schools to teach about and talk about, other than to simply point in a slogan way and say, big data. It's really important. Like Frankenstein's bonds, big data, really important. But when you drill down to actually how you're supposed to teach students about the impact of big data on their lives and careers, that becomes the challenge, the nuanced challenge for law schools in developing a curriculum. So again, in my experience, it takes precious little effort to convince the students as their eyes start getting increasingly wide that big data is important. And a lot more effort and energy to figure out how that's to be accommodated and accomplished in the development of our curriculum or our extracurriculum. But we persist. So actually, I'm not going to go so far as to say we do this in any part of our required curriculum, but then again, I doubt the same could be said of any law school, including this one. That is that we give our first year students an enormous amount of exposure to, say, predictive analytics. But I hope before our students graduate, that is every single one of them at Northwestern and other law schools, more than 20, our students, those going into litigation, going into transactional law, or going to areas of practice at the periphery of traditional practice of the law, will be able to connect the dots at some level of sophistication between the growth and arrival of big data, supercomputing, algorithmic thinking, which of course doesn't start with big data, but is enabled to be important in important ways, and what that might mean for the practice of law through the use of predictive analytics. Probably the best example, which given how rapid technological change is, probably in 3 years will seem sort of quaint, is e-discovery. But there are other examples of that as well, and we aspire to give our students that impact. So I call it big data 1 and 2. That's probably a very homely way to put the point, but that gives you some sense. And then of course we do. I would be remiss if I was at a conference on technology with having a slide that looked cool that I probably couldn't understand in any particular way. But I always aspire to impress Dan Katz and fall so very short. But then again, he falls short in impressing me, so it's an equilibrium. Big data 2, maybe it should be big data 3, which is design thinking, and Jim could much more smartly and comprehensively talk about that. I will simply say, we get it. We understand its importance. We hope 5 years from now, folks will say, design thinking, that's what we do, that's problem solving. That's great, that's our aspiration. But for now, we think we aspire to teach all of our students, not just in tech classes and not just in our clinic, to some key elements of design thinking. Here's a chart. So many could be done, right? Obviously, it's not original with me. I gave proper attribution to make that point clear, but some version or variation on that theme organizes ourselves when we teach about design thinking. And I should, as a short tangent, and I know I'm limited in time, as a short tangent, let me say a couple words about the we. The we is not me as dean. The we is not always just, it's certainly not limited to our tenure track faculty. The we includes an admixture of full-time faculty, some of whom come to these issues, a small number to be sure, come to these issues with significant salient expertise and experience. Others come to these issues as, and I put myself in this category in my non-administrative law, as some folks fairly late to the parade, but ambitious learners who are learning to learn about these topics. One of the big challenges, you might call it the holy grail, right, in terms of the curriculum, is the first year. And I think, like many folks grapple with, it's not enough, not nearly enough, to think about giving our students exposure to these kinds of issues in cul-de-sacs of the curriculum, in boutique classes found in the third year, with all due respect to those classes. What you really know you make an impact is when Jim Lupo in his contracts class sees the value of teaching their students something about blockchain and smart contracts and that kind of evolution. When I and my colleagues who teach property see the advantage of taking some precious time out, because this really is precious, particularly in Northwestern, where strangely we have 3 credit required first year courses, but I digress. In that context, to take precious time out of the curriculum to teach these concepts in the first year is extraordinarily important. But again, who is the we? So full-time faculty, adjunct faculty, who we bring in large numbers, subject to, again, a topic beyond the scope of my talk, but the rather anachronistic heavy hand of the ABA regulators, who in fact limit the scope of outside adjunct teaching in the law school curriculum. We bring in colleagues from elsewhere in the academy. We're blessed, as Michigan State is blessed, in being part of a major research university that has the capacity, if you have the resolve from the central administration and from your faculty, to bring in folks from the business school. You may have heard of our business school, Kellogg School of Management. It's a pretty formidable operation. There are folks in Kellogg who actually have extraordinary expertise in this area, as do our colleagues in the engineering school, as do our colleagues in the medical school, which is right next door. So any university blessed, like a Northwestern, like a Michigan State, like a University of Michigan, like a number of great research universities, should, and we do, avail ourselves of the expertise of others in the academy. And I say this not only because there's a Michigan Supreme Court justice here, but we do understand in Chicago the value of bringing in those who are on the front lines doing this kinds of work, like judges, right, at the state and the federal level, and we do. And they are very willing audiences. It is anachronistic to suppose that they're scratching their head saying, what is all this technology? They're actually deeply invested, like folks in other countries. So it's a big we, I guess, is my point in all this. So AI, it's come up a little bit in this conference. I suspect it'll come up more. It ought to, because it is at the leading edge and at the bleeding edge of what we're looking to teach our students about and expose our students to. And this is just a bunch of hyperbole, like quotations. There could be 100 more that all illustrate the point. You better start understanding the artificial intelligence in this way. And we're aspiring to do this really from cradle to grave. Perhaps not the best choice of words, particularly for the students who are about to graduate. Maybe that's the bad metaphor. How about from beginning to end doesn't do it. For the whole 3 years, how's that? We're aspiring to do it from the really beginning, to give our students some sense that AI actually has a meaningful impact. So things like legal search through AI, is really important from the very beginning, because our students at our law school and all of your law schools also look at legal research and writing, right, as a required first-year course. So getting them on the AI bandwagon, as it were, from the very beginning is very important. I want to make mention of a partnership that we've entered into with RSS Intelligence. In the interest of disclosure, I should say I also have a little tiny little part-time job with RSS. But that said, the law school made a choice and a decision to enter into this really interesting partnership that has 3 legs. We're one of the legs, that is our law school and the assets that Northwestern brings to the table in terms of our students and our curriculum. RSS Intelligence, a wonderful, small-ish AI startup out of San Francisco, out of the University of Toronto to be a little more exact, and San Francisco is really made some enormous inroads in legal search. And the third leg is key, which is public interest organizations, access to justice organizations in Illinois. I commend this partnership to the state of Michigan and at other states. There's nothing particularly proprietary about this. In fact, I hope this partnership will generate the same kinds of collaborative partnerships in various states that know they have an access to justice issue and are looking to the law schools in their state and also to the public interest organizations in their state and legal aid organizations to really do incredibly important work in this area. This is quintessentially Northwestern perspective on this, meaning that we're really pioneered this. Although I suspect in a couple years we won't be able to say that any longer. This will be a wider phenomenon. But we're really interested in moving from the training of lawyers, our bread and butter, right? Creating newly minted JD holders who are going out into the world and become world beaters and leaders, just as happens at this law school and so many other places. But also seeing our obligation to train folks who are not aspiring to be lawyers, but who will help significantly in the provision of legal services. Because we know the 80% figure, right, gets bandied about. We know that 80% of American citizens have no access to lawyers. We know that there's a movement afoot, and long been a movement afoot, that's gaining an amount of traction, to notwithstanding the ABA and other regulators, to enable non-lawyers to provide significant legal services. Until fairly recently, law schools have been out of that debate, right? It's like, well, that's all fine and good, but that's not what we're about, because we're about the training of lawyers. So we've actually at Northwestern thought about ways in which we can expand our mission and our bandwidth to do more than just the training of lawyers, to provide really solutions, helpful solutions to access to justice and legal service issues, and also take advantage of what we fundamentally believe, which is the world of law and the future of law, is training folks who can work at the intersection of law, business, and technology, not just in law and not just as lawyers. So we devised 4 years ago this innovative new program. MSL stands for Master of Science in Law. It's a 1-year full-time program or more than 1-year part-time program open that provides business center, it should be law and business center legal training, right, exclusively for STEM-trained graduates, by which we mean folks who come to the program with a background in science, technology, engineering, mathematics, or medicine. They might be right out of college, although more typically they're out of a graduate school or have some time in the industry. It's focused on STEM professionals and what they need to know. All of the courses are standalone courses. They're not available to JD students, with the exception of the Innovation Lab. And so they are really designed for students in that particular program. As I say, it's an intensive 1-year degree. Key opinion leaders. My favorite, and then tied for my second favorite, not counting Jim, who if I remembered he was going to be here, I would have put him up on the slide. Again, quotes, you could find the same sorts of quotes from all sorts of folks. Need to develop connections. Entrepreneurs must understand the legal and regulatory framework. The future will involve, I should even say the present involves, the increasing de-siloing traditional roles, the emergence of professionals. Here are some of the questions that these professionals need to know, and don't need to be lawyers in order to need and want to know the answer to it. Do you know how to protect your company's intellectual property? Do you invent something while working at a company and under a written employment agreement? Do you understand the regulatory requirements involved in bringing a product to market? These questions. All of them key questions for entrepreneurs, business folks, C-suite executives, aspiring C-suite executives, regulators. The MSL program, in its curriculum, sets out to help our students to develop answers to those questions that are so central and so salient, and here's the blasphemous comment, don't necessarily require or even want the contribution of highly priced lawyers in order to answer those questions. Or to put it another way, we're training clients. We're training clients. We're training folks who are going to be really important partners with lawyers in order to solve these particular problems. I got to brag on this. Any interest in diversity, interest in more mature students, interested in students with a confluence of degrees, just look at our program, look at the background of these. And again, we're in our 4th year of the program. We've had more than a couple of hundred. So this field of dreams idea, which we started it with, if you build it, they will come. But we're thinking, I hope they come. Because this is a really good idea on paper, but maybe there's not a market for this. Because after all, think about it from the vantage point of an employer. Now, what's this degree exactly? What are you talking about? I always use this phrase, and Jim and Allison and Jesse have heard it more times than they care to remember. I say, well, if that's the argument, is, well, an MSL is nothing. It doesn't provide you a credential to do anything, unlike a JD where you can practice law, unlike an MD. I say, what do you think it was like 50 or 60 years ago when business schools invented the ABA? The ABA, if you'll pardon my French, doesn't give you a credential to do a damn thing. No one needs an MBA to run a company. The MBA became a marketable, important degree because the market started to recognize it as an important, credible degree. I'll whisper, let's see whether that's the case 20 or 25 years from now. But for now, it's a very important degree. The MSL degree, I think, has that same salience to it. Just quickly run through this. There's a series of required courses. I hope you will see that as, wow, these are terrific courses, important courses. Obviously, some overlap with what we teach in the regular JD curriculum, but these are required courses for our students in that. I've taught that course every year since the invention of the program. I've taught every MSL student because I've taught the required course in legal and regulatory process. So if they turn out to be awful, you can blame me on that. I'll brag a little bit more. Here's some of the members of the faculty who teach in this program, in addition to full-time faculty members. So you can see they reflect a wonderful cluster of world beaters, of really interesting folks from a diversity of careers. Some are parts of big Northwestern in the different schools. Some are entrepreneurs, work in consulting firms. Just a great collection of, I gotta say this, it's miraculous. They basically teach for free. They don't do it for the money. So these are folks who are really invested in the program by their work involved. And here are some you say, well, what jobs could they possibly do with this particular degree? And here's an insight into all of that. Now, I sort of bait and switched Dan because he probably didn't expect this to be so much of an infomercial from the MSL. So I'll try to broaden it. So I'll get off the infomercial bandwagon and I will wrap up to say, this is just a window into innovation. It's a kind of innovation. The MSL program's not for every law school. The kind of program and the intensiveness and the resource intensiveness of the program probably can't be regulated in 200 places, although I suspect in the years to come it'll be replicated in a handful of places. Other schools will pursue other kinds of innovation. But I will get up on my soapbox to say the following. I do believe there is a responsibility on the part of our great American law schools, yours, mine, others, to seek out opportunities for educating folks who are not going to be JD holders, licensed to practice law in the traditional way. In other words, I think we do have to broaden our mission. And part of the de-siloing that I'm talking about is integrating with business schools, integrating with engineering schools, integrating with tech firms and others who might actually want to utilize law, learn law and utilize law for a variety of ways. I believe that's an imperative given the access to justice gap, but it's also imperative because of the deployment and use of technology, many positions of which do not require having a JD. So think about the tech companies for a moment. We are pushing very hard, law schools have been pushing very hard. I remember this from the Stanford conference about 3 years ago when the summit that sort of gave rise to the Center on Innovation. A lot of the tech companies were like, in essence saying, well, we started all these tech companies disparaging lawyers, thinking, oh, we're going to do something different. If LegalZoom did not have to hire gaggles of lawyers, we don't have to. And of course, most of those tech companies failed. One important reason why most of them failed is because they didn't get the law side right? They didn't integrate sort of a lot of these understandings of law. They were so quick to disparage big law, and there was a lot to disparage, they forgot the message that actually there are folks who need to come to these tech companies who need to have more training than just a fancy engineering or computer science degree. A program or initiative like the MSL or other variations on that same theme aspire to give folks the kind of education and training that enable them to make palpable, concrete contributions to technology jobs where those companies don't require somebody to go 3 years, pay astronomical tuition, go into crushing debt, take a bar exam, just to go into to a company that does not require any of that in order to function importantly in the profession. I was very glad about Jordan's talk a little bit ago, which I found extremely helpful in mapping out how a school should really run an innovation lab right. And I'm sure Alice and I were both, incorporating a lot of that because we too have an innovation lab. We're trying to figure our way through, and we have a variety of. I think we're probably lower down in the learning curve in terms of the developing it. One area, though, that I want to highlight about our innovation lab that I commend to you as well is it's palpably multidisciplinary. We have students in our innovation lab, certainly in the JD program. We have MSL students. We have foreign LLM students, and we have computer science students from the McCormick School of Engineering. And I got to tell you, that has been challenging, as you can well imagine, in ways I could barely describe here, but fascinating. Bringing those folks from different fields, students from different areas together on that common one. I have exhausted Dan's patience, so I'm going to stop there, and I'd love to answer your questions or continue this discussion. So thanks.